Shengnan is going to speak about the nature and validity of bill of lading issued by China Europe Railway Express from the Chinese perspective. Yeah, you have all the relevant information on Shengnan in the conference booklet. So I just wanted to introduce you and show you.
First, I would like to say thank you for all organizers to invite me for the second time. I attend this conference. Unfortunately, this year I can visit Croatia personally. I really hope next year everything is done and I can go there. You can see the topic is nature and the validity of the bill of lading issued by China Europe Railway Express from Chinese perspective. The thing is, this is a maritime law conference normally, but my presentation is a little bit far away from maritime law. However, when you look at bill of lading, you will think it is not very far, because bill of lading, definitely that is a traditional ocean concept for many years. So I try to focus on this topic because at the moment, this is a very hot topic in China, and also Chinese government has submitted a proposal to UN commissions on international trade law to consider how or to what extent a railway bill of lading can be treated as the function of document of title. So I think this is very meaningful. Well, you can find the agenda. In this presentation, there are 4 sections. First, I will give a short introduction and from 4 aspects. First, let us look at what is the development of the China-Europe Railway Express. Secondly, I will compare a railway consignment note with an ocean bill of lading. What is the negative points from the railway consignment note? The third point in the first session is to look at how Chinese government try to contribute to the use of the railway bill of lading. And following this, you will find how developed a railway bill of lading in China. Well, this is the first section. The second section, I will examine the first judgment of a Chinese court made as to the legal nature of a railway bill of lading. And the third section, I will try to explore under the current legal framework, does the Chinese judgment has adequate legal foundation to treat the railway bill of lading as the function of document of title. And finally, we will look at the conclusion and the expected development. Well, first, let us look at the background. I think here, my dear European friends and colleagues, China-Europe Railway Express, you all familiar with this express, I think. But even so, I want to give a short background. The thing is, the first China-Europe Railway Express was launched in 2011. The first train route is from Yu means Chongqing to Xinjiang, O means Europe. So this first China-Europe Railway Express is between Xinjiang and the destination is Germany. But the thing is, after the first express, between 2011 and 2013, the railway express has not developed quickly. But in 2013, Chinese government launched the Belt and Road Initiative. After that, the Railway Express has been sharply improved in the number of operations and the categories of cargoes transported. At the very beginning, actually only electronic stuff transported by the Railway Express. Okay, up to the end of 2020, the Railway Express has connected 71 Chinese cities to 92 European cities from 21 different countries. Last year, I think everyone known that air transport and maritime transport was suffering from very bad situation. But from the Railway Express point of view, the market was going up, and also the railway freight was going up. But of course, compared to air freight and maritime freight, is the still reasonable price. Well, this year, in the first half of this year, the Railway Express transported 1.85 billion tons of cargo from car, electronic products, household stuff to medical supplies, up 8.9% year on year. It is anticipated that the Railway Express will play an important role in transport between China and Europe. However, the thing is, the Railway Express is not like maritime transport to use a bill of lading. It's in Railway Express just use consignment notes. So what is the difference between assignment note and an ocean bill of lading? First, they have two same functions. They are both evidence of the carriage contract. They are both cargo receipts. But unlike the ocean bill of lading, the consignment note is not a document of title functioning as a negotiable instrument. Because of this reason, the consignment note cannot be used for the settlement and the financing of letter of credit as an ocean bill of lading does, thus limiting the ability of banks and other institutions to provide financing services and increasing the financial pressure on importers and the risk of payment collection for exporters. But of course, I need to emphasize that under UCP 600, banks can accept railway consignment notes. However, in practice, I have to say that it's not just the Chinese banks. I trust other jurisdictions' banks do not like to take the railway consignment notes. So for this reason, the Chinese government would like to use the different way to give the different concept of consignment note. Because if the consignment note is like the ocean bill of lading as the function of the title of document of title, it means more companies can use this railway consignment note to get money from the bank. They don't need to worry about financing issue. So what is the Chinese government try to do? First, in 2017, the State Council issued overall plan for the China pilot free trade zone. In this document, this is a governmental document, or maybe say regulation. In this document, it is provided that it should establish an international multimodal transport logistics system. Also, depending on the railway express, it is to frame the international trade corridor and the rules. In China, always policy, Chinese government document is the priority from the different phase. So because this policy in 2017 issued, then the relevant authorities or relevant departments tried to follow this policy to do something. First, in December 2017, in Chongqing Pilot Free Trade Zone, the first documentary credit crossed the world, which could be negotiated by a railway bill of lading, was issued. Following that, just the early of 2018, 9 authorities in Chongqing municipality released guiding opinions on developing trade by land and promoting financing by consignment notes. In these guiding opinions, it is provided that to improve the issue of multimodal bill of lading and land. Here, it's land, but actually it's to refer to a railway consignment, where a multimodal bill of lading and a land consignment note comply with the relevant legislation and regulation. All banks shall treat such bill of lading and the consignment note as an effective document to use for the international settlement and trade financing. Well, the thing is, here is mentioned all banks. Actually, this is the government and try to instruct the banks to accept consignment notes as the function of document of title. Well, in 2018, the State Council further released another document, which is several measures for supporting the deepening of reform and innovation in parallel free trade zones. In this document, again, it is provided that in order to enhance the carriage of goods by international railway, Ministry of Commerce, China Banking and Insurance Regulatory Commission, National Railway Administration, and the China Railway Corporation shall support the competent free trade pilot zones to research on ground and international railway consignment note as the function of the document of title, and to explore a railway consignment note as a negotiable document and a letter of credit. Well, here I want to mention several departments. First, here is mentioned Ministry of Commerce and China. This is the Chinese, belong to Chinese government, but China Railway Corporation, actually that is just a company, it's not government. So from this instrument, you can see, based on the policy, the Chinese government tried to guide not just government, but also companies, banks, to do some research how the railway bill of lading can be used as the function of document of title, and also try to make it happen. Okay, so based on the positive policies we have examined, what happened? The following is a railway bill of lading. This concept officially has been released, has been launched. And just now I mentioned on 2020 December 2017, the first documentary credit across the world has been issued. And this year, earlier this year, in Zhejiang Pilot Free Trade Zone, also used railway bill of lading. The thing is, officially they use consignment note, but I checked the news. They just use consignment note, but actually the content, which is the bill of lading. Well, in practice, how the railway bill of lading is workable. The thing is, in practice, in the letter of a contract, a carrier or freight forwarder issue a bill of lading in addition to the railway consignment note. It means there are two documents. One is the traditional consignment note, but another is the railway bill of lading. Well, the railway bill of lading is used as the sole proof of delivery, and the freight is controlled by the carrier or freight forwarder throughout the whole process. The consignor will use the bill of lading for financial settlements with the bank, such as negotiation, foreign exchange settlement, and bill purchase. The consignee will obtain the bill of lading from the issuing bank after fulfilling its obligations and take delivery of goods from the issuer accordingly. Okay, after we look at the background, let us look at the first case as to the legal nature of the railway bill of lading. In this case, you can see this map. From this map, there are three legal relationships. First relationship among importer, IMAS, guarantor, Chongqing Logistics Finance Service, and freight forwarder, Sinotrans Logistics. This is the first legal relationship based on an agreement. We will look at the detail later on. The second legal relation between importer and China spare. Their relation is based on a sale contract. After importer imported the car from Germany, and then in China, they sold the car to China spare. This is the second legal relationship. The third one is Fuqi Automobile and Sinotrans Logistics. The thing is, after the sale contract had been signed, Fuqi Automobile was as a holder of a railway bill of lading. And then Fuqi, depending on this railway bill of lading, requested freight forwarder to take delivery of cargo. So there are three legal relationships. Well, there are three crucial legal issues in this context. First, governing law. The thing is, this is a foreign related civil relationships. But according to Chinese law, the parties may by agreement choose the law applicable to rights in rem in movable property absent any choice by the parties. The law of the place where the property locates when the legal fact occurs shall be applied. In this case, no agreement has provided governing law. It means no chosen governing law. And the delivery of cars happened in Chongqing. So for this reason, Chinese law and the primary court of Chongqing Parallel Free Trade Zone had jurisdiction over this case. Okay, the second legal issue, which is very important, because it is to address whether the claimant as the holder of a railway bill of lading entitled to take delivery of cars. Just now I mentioned the first legal relation in this case happened among three parties: IMAS importer, Sinotrans freight forwarder, and logistics, finance services guarantor. So in this agreement, first, three parties give a very clear concept of a railway bill of lading they used in their transaction. It is a railway bill of lading as a document issued by a freight forwarder that certifies that the goods have been received or loaded by the freight forwarder and transported to the destination port and guarantees the delivery of the goods. Such document is an uncontroversial and exclusive document of title to take delivery of cargo. Based on this article, Chinese court thought this article actually is to clarify the railway bill of lading had the function of document of title. Okay, Article 3 in this agreement provides that IMSA shall not contend that he is as a consignor to unilaterally request Sinotrans means freight forwarder to deliver the cargo. Well, this article, Chinese court held that it means the status of an importer cannot prove that he is entitled to take delivery of cargoes. Only a holder of the bill of lading is entitled to do so. Well, Article 7 in the agreement provides that IMSA is only entitled to take delivery of the cargo on basis of the original railway bill of lading. So based on this, Chinese court held that the railway bill of lading amounts to the right to take delivery of cargo. A railway bill of lading is an negotiable instrument. So this is the legal reasoning of the Chinese court made. In other words, in this case, Chinese court held that the claimant as the holder of the railway bill of lading should have the right to take delivery of cars. But what's the third legal issue? The third legal issue is that the Chinese court examined the validity of endorsed railway bill of lading by IMSA and the guarantor was valid or not. Well, the thing is, just now we mentioned agreement among guarantor and the IMSA. In this agreement, the IMSA applied for financial settlements with the bank by way of bill purchase and the Chongqing Logistics Finance Service as guarantor provided security, and the IMSA used the railway bill of lading as the counter security. And after that, IMSA paid for the full amount in due to guarantor. And the IMSA and the guarantor endorsed the railway bill of lading to Fuqi, China's buyer, based on the sale of contract between IMSA and Fuqi. But after Fuqi received the endorsed railway bill of lading, he requested the freight forwarder to take delivery the cost. The defendant freight forwarder refused. And the thing is, the Chinese court held that because the endorsement was the document continuous. So it means the endorsement was valid. But what is the applicable law? The Chinese court used property law. Now this property law was abolished on 1st January 2021, but Civil Code 2020 has incorporated the same article into the new code. That is the Article 227. It is provided that where a third party has taken possession of a movable property prior to the creation and transfer of real right of the movable property, the party under an obligation to make delivery may substitute delivery by transferring the right to require the third party to return the original property. Okay, based on this article, the third party in this case refers to the freight forwarder, and the railway bill of lading was a transferable document, and the party, Fuqi, used this transferred document, has the right to take the cargo. So this is the Chinese court made the decision. First, the railway bill of lading could be treated as the function of document of title if only the bill of lading had been endorsed constitutionally. Well, let us look at what is the current legal framework under Chinese law. I don't want to give the direct answer, what is my opinion about this this first judgment made by Chinese court. But I think after we examine the current legal framework, you can have some idea what is the correct or not correct of the first judgment, or maybe partially correct. Well, in this section, let us address three questions. First is the concept of a railway bill of lading in existence under Chinese law. Secondly, does a consignment note enjoy the nature as document of title? Thirdly, is there an adequate legal foundation for forwarding the consignment note, the status and the validity of a bill of lading? Well, may I ask how many minutes would I have?
You have some 5 minutes left. Okay.
5.
Yeah. More.
Okay. I will speed up. And okay. And the first, international regime. There are two major intergovernmental railway organizations. Firstly, is the international international conventions made by Intergovernmental Organization for International Carriage by Rail. This is the more popular compared to another one. But China is not the state member. Based on this convention, it is mentioned the consignment note shall not have effect as a bill of lading. So it means the railway consignment note has no function of document of title, actually. The second convention made by the Organization for Cooperation Between Railways. This convention normally only normally it's a few countries join it, and only 29 member states, but China joined it. But the thing is, in 2017, Chinese government allowed the shipper to choose CIM waybill or CIM consignment note or SMGS consignment note. It means Chinese parties have a right to choose which convention can be used or which consignment note can be used. And also in this convention, there is no any express provision to say that consignment note has the function of document of title. So this is the international regime. In order to harmonize the railway transport documents, these two international organizations tried to work to figure out with one consignment note. So that is CIM, SMGS consignment notes. However, these notes haven't been used widely. At the moment, these notes still lack the same functionality and is therefore not of the same nature as document of title. So this is the international regime. Well, what is domestic law? From the domestic law point of view, in China, railway law just mentioned a railway transport contract shall be an agreement in which the mutual rights and obligation between the railway transport enterprise and the passengers or shippers are defined. And good consignment note shall represent a contract or a consistent part of a contract. Here it doesn't mention a railway bill of lading, also doesn't mention consignment note can be treated the document of title. Another regulation, which is rules of carriage of goods by railway. Similarly, in this regulation, doesn't treat consignment note as the nature of document of title. So from the perspective of special law, no concept of a railway bill of lading and a consignment note has no function of document of title. Okay, that is from the general law point of view. First, document of title follows that the holder of a bill of lading enjoys the right to take delivery of cargo. Accordingly, such bill of lading can become the objective of pledge named the pledged property. This is a general law, give the concept of document of title. In accordance with Civil Code 2020, bill of lading can become the pledged property. Why? Because bill of lading under Chinese law has the function of document of title. But here doesn't mention the consignment note. Well, Article 440 of Civil Code 2020, it also mentions other property rights that can be pledged as prescribed by any law or administrative regulation. What the meaning? It means if consignment note hadn't been incorporated into this article directly, we can look at some other law or administrative regulation. However, no any law or administrative regulation has provided the consignment note can become the pledged property. It means the consignment note cannot be treated as the document of title. Well, another thing is Article 115 of Civil Code 2020, it's mentioned property shall include real property and the movable property, where rights are deemed as the objects of real rights by provisions of the law. Such provision shall apply. So based on this article, actually is to emphasize that if the consignment note can become the document of title, the law must give express provide. But of course, based on the Civil Code 2020, Chinese as civil law tradition has the flexibility of numerous clauses. But unfortunately, even so, the consignment note cannot be treated as document of title because there is no law. So you cannot see, based on Chinese domestic law, there is a legal foundation to treat the consignment note as the document of title. Well, whether the Maritime Code
I think the time is really up. I already awarded you the 5 minutes. Mijo said in his presentation. And
okay.
Speak afterwards. Could you perhaps just in a couple of sentences complete your?
Okay. Okay, got it. Just several sentences. Okay, Maritime Code 1992 treated bill of lading, ocean bill of lading as the function of document of title. But again, based on the numerous clauses principle in China, you cannot say that the consignment note or a railway bill of lading can be copied the Maritime Code 1992. And finally, let us look at conclusion. I think the nature of a railway bill of lading as the function of document of title should be prescribed by law directly, and the freedom of contract may provide contractual parties an opportunity to grant a contractual railway bill of lading as the function of document of title, like the case we examined. And the customs and the practice may grant the railway bill of lading as the nature of document of title, like an ocean bill of lading. But because the railway bill of lading just be used in the past several years, so there is no customs and the practice can be applied. Expected development, as mentioned at the very beginning, Chinese government has submitted to the UN Commissions on International Trade Law a proposal. At the moment, the UN has given a very positive view to examine whether the development of a negotiable transport document to facilitate multimodal carriage of goods, particularly by railway in the EU and the China space, can be used or not. So let us look at the future. And I'm on this research project. If anyone are very interested to this research, we can work together because, and apart from me, my team is also on this. So welcome to contact me. Thank you. Thank you for your time.